Welcome to Books of Our Time, brought to you by the Massachusetts School of Law and seen nationwide. Today we shall discuss Failing Law Schools, a new and much noted book about problems in many law schools. The book's author is Brian Tamanaha, formerly the Dean of St. John's Law School and now a professor at the Law School of Washington University of St. Louis. Usually my guest joins me in the studio at the Massachusetts School of Law in Andover, Massachusetts. Because scheduling difficulties made this impossible, the interview is being conducted with Professor Tamanaha in St. Louis and me in Andover. And I am, of course, the regular host of Books of Our Time, Dean Lawrence R. Velvel of the Massachusetts School of Law. So Brian, thank you for being with us. And let me begin by asking you to explain in broad terms why you think law schools are failing.
The cost of obtaining a law degree today is far out of proportion to the economic return on the degree for the majority of students. So let me give you a few statistics that demonstrate that. The ABA recently released statistics on the class of 2011. 9 months after graduation, only 55% of graduates of law schools nationwide, 55%, had obtained permanent full-time jobs as lawyers. Meanwhile, the average debt of law graduates upon graduation was over $100,000. Now, the problem is not just that there are significant numbers of unemployed graduates, it's also that many of the graduates who do obtain legal jobs don't earn enough to make the monthly payments on the average debt.
In your book, you present in detail quite a few reasons why this unhappy situation has arisen. And while I presume that people are not arguing with the statistics that you just presented, what has been the response so far, at least, to your views of the reasons why this situation has come to pass?
Well, first, let me say some people are denying the argument I'm making that a law degree is a highly risky investment. In a recent article in the National Law Journal, for example, the current chair of the ABA section on legal education suggested that I was exaggerating the situation. So there are defenders of the current status quo in legal education. They also suggest that I failed to take into consideration all of the non-financial benefits of having a law degree. And one of the points I try to make in the book is that you can acknowledge that there are many benefits to having a law degree, but if you can't make the monthly payments on your debt, then you're in financial trouble, and I try to focus in the book on that. I should say I haven't heard many responses in detail to the book yet, but in terms of the causal arguments, I haven't had many responses so far. The basic argument I make is that the economics of legal education have gotten out of whack, essentially because tuition has gone up every year for over 3 decades, and I mean every year. And meanwhile, pay for the bulk of lawyers has stagnated. The corporate law legal market, pay has gone up quite nicely in that respect, and people who obtain those jobs are doing fine. But the pay for the bulk of lawyers has not gone up, and as a result, they now pay much more, and yet the economic return they've been getting has not gone up to keep pace with the rise in tuition. That's the basic problem. As I said, I haven't heard too many responses. I expect there will be critical reactions to the arguments I've made, but thus far I haven't heard any.
The book is very East Coast centric, Wall Street centric, one might say, but that would include, the corridor from Charlottesville, Virginia, up through New England. It would also include the University of Chicago and Michigan and Northwestern. And then the argument goes, it sort of leaps the country, kind of like the New Yorker's view of the country, that cartoonish thing. It kind of leaps the center of the country to the West Coast. And in short, the problems that you see with regard to costs and availability of jobs don't exist to the same degree everywhere. What is your view of that criticism?
Well, the statistic I gave that only 55% of the graduates obtained full-time permanent legal jobs, that's a nationwide statistic. It's not focused in any particular area. But it is true that many very expensive law schools are located in large urban areas. The law schools in New York City, for example, as well as Boston, as well as Chicago and LA, are the most expensive. And so the debt that students at these schools come out with are much higher. When I said the average debt of graduates nationwide is $100,000, I need to emphasize that the 10 most indebted schools, the graduates from the 10 most indebted schools, had debt over $140,000. And all of these schools are in major urban areas. Many of them actually are schools in LA, Chicago, and New York. Schools in these urban areas are the most expensive. The debt of their graduates is the highest. And it's also true that their states, flagship state schools, which I mentioned at the end of the book as the last remaining affordable corner within accredited law schools, many of those schools, their tuition is $15,000 a year. The average debt is $50,000, and I suggest that these schools are actually working.
Well, that's the impression I received both from your book and from hearing people who saw you and William Henderson speak at a conference recently. And I was very pleased to hear it because, given the fact that much will be said on this program, which is critical of law schools, I feel an obligation to our own school and to my faculty to point out that we're among that latter group that you're talking about that have a much lower tuition and students come out with much less debt. Having made my reverse mea culpa, I guess one might say. Be that as it may, you take the position the poor and the middle class, if this continues, are going to be shut out from a traditional avenue of social and economic mobility, and from a very important part of this power structure of the country. Maybe you could elaborate that.
Sure, I think there's no question that is one of the worst consequences of the current situation. In the book, I focus on the consequences to individual debtors, but there are also social consequences, erecting such an enormous economic barrier to access to the legal profession. So let me again give you some numbers. Private law schools, the tuition at accredited private law schools ranges from about $35,000 to just over $50,000 a year. In addition, you have to consider living expenses, costs for books and so forth, which at many schools approximates $18,000 to $20,000 a year. If you add that up, the cost of a legal education at a private law school totals between $150,000 and about $200,000. Now, obviously, this isn't only about the poor. Middle class, people from middle class families can't afford it as well.
We've been unclear around here whether those figures you're citing are for law school alone or whether they include debt for college too.
The debt figures I use relate exclusively to law school.
To which one would there also then has to pile on college debt.
That's correct.
Okay, go ahead.
That's correct. And the average debt of college graduates today is about $25,000. So whatever debt numbers I give you, you could add $25,000 on top of that. The cost of an education at a private law school, the total cost ranges between $150,000 and $200,000 today. And that actually begins to inhibit even middle class people. So I'm not even talking about the poor. I think they've always been in a difficult position. So the long-term social consequences of this, I think, are quite significant. There's one other element of this that matters, and that is the legal profession in particular is a very elitist profession. And what I mean by that is that people in law pay attention to credentials and where you got your law degree from. And the best example we can point to today is our own Supreme Court, which has graduates of Harvard and Yale. A number of graduates from Harvard on the Supreme Court throughout history, and it adds up to a bunch of schools combined. So it's not just that the cost of becoming a lawyer is getting higher and higher, that the cost at the most elite schools is the highest of all. And as a result, it seems not just that we'll have more and more lawyers from the wealthy class, but more and more lawyers controlling elite positions within our government, within corporations, will come from the wealthiest class.
I think the exact figures are that on the Supreme Court, 6 lawyers, 6 justices are from Harvard, and Ruth Ginsburg was from both Harvard and Columbia.
That's right, yes.
And 3 are from Yale. This means that 2 schools, essentially, are exercising control, total control at the very top of the profession. And that there's no question, I think, that it's the most elitist-oriented profession in the country. I have read engineers who find it unbelievable when they read about the degree of elitism and seeking of prestige in the legal profession. And that's engineers, no less. But I take it that is the reason why you say that nobody gave a darn about the situation until it started to affect and afflict, I guess one could say, the schools like Harvard and Yale.
Yes. The oversupply of lawyers, the number of graduates that we've been putting out exceeding the number of available positions, has been with us at least for 10 years. I trace it back to 2001. I couldn't go back earlier because they changed the way in which they counted, compiled the statistics. But essentially, since 2001, we've graduated over a third more lawyers than there were positions. So unemployed lawyers ranged from about 65% to about 70%, unemployed recent graduates. But no one said anything about it, and no one said anything about it until the contraction in the legal market, which hit us in 2008. And when that contraction hit, people that were suffering were people from elite law schools. They had their job offers rescinded. They had their starting dates put off for 6 months to a year. And it's when that happened that everyone began paying attention.
Isn't there some similarity, a problem in the medical and dental professions, which is too many graduates chasing the same kind of job in too few places, meaning the big urban areas where big law is practiced, and ignoring the rural and middle parts of the country?
Dental profession also had an oversupply problem, and to deal with it, they actually closed a number of law schools.
Including Georgetown's.
That's correct. And so we've not done that. We've had an oversupply problem for, as I said, at least a decade, and I believe much longer. Part of the problem has to do with the argument or the belief that a law degree is a versatile degree, and certainly legal educators constantly say that you can do many things with a law degree. It doesn't mean you have to be a lawyer. That's in contrast to a dental degree in which you're either a dentist or you're not doing anything. So this is a big difference, that in medical schools and dental schools, they've managed to match the supply with the available positions. You're also right that a part of that is encouraging people to go and serve underserved areas. It's not clear to me that we have that same problem in law. I mean, there are certainly towns that don't have lawyers, but it's part of the reason is because the people in these towns don't have enough money to afford lawyers. So bringing a lawyer there, it's not clear to me would work economically. Now, part of the reason it doesn't work economically is because our recent graduates have high debt, so they can't afford to serve the low-end legal market. One of the perverse things I point out in the book is that we have at the same time a substantial oversupply of lawyers, law graduates, to jobs, and yet substantially underserved legal needs. The Legal Services Corporation comes out with a report basically every year documenting huge numbers of unfilled legal needs. In a recent report, they said that they turned away about 1 million people who otherwise would have qualified for their legal services, but they didn't have sufficient manpower to do it.
For a lot of people, some of whom do become practicing lawyers and others of whom do not, going to law school is, well, I don't know how else to put it, it's a dream come true.
Historically, the legal profession has been a path of upward mobility, often from immigrant families, second generation. My own family comes from Okinawa, and I was the first lawyer in the family. And as you say, it's not just about finances, it's also about status, but it's about much more than that. Lawyers participate in local government. Lawyers, as you said, become politicians. In various ways, lawyers have an impact on the community. And I am concerned that the economic barrier to access to the legal profession that we've erected will have social implications beyond what we're talking about, beyond just what it means to be a lawyer and pay the bills.
I couldn't agree more with you. I mean, there's a whole avenue of social mobility and economic advancement being closed off. Much of the problem apparently has arisen because a couple of organizations managed to obtain a tremendous influence over accreditation of law schools. And if I understand your book correctly, in 20 years of my own study, they used the accrediting body, which is the ABA section of legal education and admissions to the bar, to require universities and law schools to do a lot of things which ended up increasing costs dramatically. Now these three organizations, two of whom you mentioned, are the American Bar Association and the Association of American Law Schools, also the Law School Admissions Council. Now, can you explain a little bit about how these three groups sort of coordinated themselves and sometimes have been called the big three of legal education? You don't use that phrase. Can you explain, as I say, just a little bit about how this cooperation came into existence and what it's meant?
The ABA and the ALS together have essentially regulated law schools, the ALS through its own set of standards and the ABA through its set of standards. But I should emphasize that many of these are the same people. They circulate through these positions. In the book, I focus on the fact that late in the 19th century, early in the 20th century, the schoolmen, the people in the law schools, were unhappy that the ABA didn't have a particular body focused on law schools. So as a result, they created two organizations. One is the ABA section on legal education, and the other is the Association of American Law Schools, essentially to regulate law schools in a way that, in my view, ultimately had the interests of legal educators, if not foremost in mind, then at least equal to the interests of creating institutions that train lawyers. And when I say that because the standards incorporated elements that focused on academia. For example, standards related to teaching loads, standards and interpretations, I should say. Some of these were not official standards, but they were interpretations put into the standards. They also focused very heavily on pay, initially, on the pay that law professors earn. Now, when these provisions were written in, they were always written in with the justification that it was for the good of training lawyers. They didn't say that it was for our own good, that we want to teach less, that we want to earn more. Their arguments were that if you don't allow us to earn more, if we don't earn more, we won't have as law professors who are any good. We won't be able to attract law professors. And that if you don't allow us to, if you require us to teach too much, you won't have scholars. And to teach law school, we need scholars to teach law school.
I would say that the legal academics have wanted to be treated as academics for purposes of what they do in their job, and as lawyers for purposes of how much money they make. And you have some figures in your book which even I, as jaded as I have become in 20 years, found absolutely staggering about law professors at some schools, many of them making in the 300s. And even though the Department of Justice, as you again point out in your book, and you've pointed out here, told them to stop this price fixing of salaries, the mindset had been built in, and things have just continued on apace. Maybe you could explain very briefly the process that was used by the accrediting body to ensure that salaries went ever up. And let me say that I think as a result of your book, Brian, I read the book by Thomas Morgan, which you cited, was saying, you know, we must get salaries up because otherwise we will have inept law professors. And he cited what the salaries were in those days, and they were as staggeringly low as the salaries are staggeringly high today. Maybe you can just give a brief view of the process that was used to get salaries up.
think the most current picture of faculty salaries can be gleaned from University of Texas. The dean of University of Texas was recently fired, essentially out of a faculty revolt over salaries and monetary awards that professors were getting. And I guess some in the faculty thought it was unfair, so they filed a public information request. So the faculty salaries for Texas were posted online, and the numbers are shocking. 19 professors at Texas earn over $300,000. Another 35 professors earn between $200,000 and $300,000. In addition to that, I believe it was 20 professors received one-time grants in the form of forgivable loans, ranging from $75,000 to over $300,000. In addition, the dean himself got a one-time grant of $500,000. Now, these grants came from the Texas Law Foundation, which is a very wealthy foundation. But nonetheless, these are forms of compensation. So we're talking real money here. This is Texas. I assume that the elite law schools, top 5 law schools, are the same kind of monies in play.
Yeah.
There are two different sides to this. One is the low-end salaries at most law schools, and then one are the salaries at the high-end law schools. At the low-end law schools, the impact of the ABA is most direct, because the ABA provisions essentially said that, and again, these are more the interpretations rather than the standards, but they're also official interpretations.
Right.
They were written into the body of rules. Suggested two things. One is that any school below a comparable median, and by that they would compare to other like-situated schools, any school at which the salaries were below comparable median raised questions about the sufficiency of the compensation. And then there was another provision that said any school at the bottom is presumptively in non-compliance. So the operation of these two provisions was essentially to ratchet up salaries on the bottom, because there's always some law school at the bottom. So the argument is we're at the bottom or near the bottom, we're not in compliance. And there are always half of the law schools at any given time below the comparable median. So through these provisions, after doing accreditation inspections, reports could be written to say that the faculty's not being appropriately compensated. And in fact, this was open knowledge at the time. I quote Dean Cass of BU saying, it looks like these accreditation visits are really about trying to pry more money out of the dean, the law school dean, for the faculty, and then trying to pry more money out of the university relative to the faculty. Now all of those provisions have been taken out, but nonetheless it had a ratcheting up effect, and that effect continues today, because the new levels of salary, subsequent raises are often based on percentage of existing salary, for example, and new hires come in and are pegged on existing salary. So that lifted up collectively the bottom half, the lower salaries at the lower range law schools. That doesn't explain the extraordinary salaries that are now being obtained at the top law schools. What explains that, and now I'm talking about Harvard, Yale, Michigan, essentially is competition for star professors. Law schools have really now engaged in recruiting wars for more than 10 years, about 15 years, even longer actually. And this relates to our extraordinary chase for prestige. Law schools are now competing, and we often say this is about U.S. news, and indeed it is, but it's also about the fact, as I mentioned earlier, that legal academia, the legal profession in general, but I want to emphasize legal academia in particular, is very elite-oriented, very prestige-oriented, and we sort of had this frenzy about recruiting professors. And the common ways to recruit professors are to offer higher pay and to offer lower teaching loads.
A few years ago, the Daily Cavalier of the University of Virginia, which is the undergraduate school's newspaper, found out and published the salaries of all the professors at the Virginia Law School. This is public information somewhere in the Secretary of State's office, perhaps. And Brian, I have to tell you, not just that I was astounded at the level of salaries, but I was astounded at the fact that some of the most prominent and well-known and prestigious professors, persons whose names I had known for 25 and 30 years, were among the lower paid persons on the faculty. The goodies went to the people whom the university was trying to hire away from elsewhere. Well, they just brought up the rear, and that's just the way it was. When you point out that there's been this mad competition for professors, these are basically, as I have always understood it, and I think your book says the same thing pretty much, are research-oriented professors. And that leads to the question of, number one, how does one get to be a prominent, aside from the fact that you must write, of course, or at least type, how does one get to be a prominent research-oriented professor, and why the extensive stress on research, and is this of benefit to the students?
To become prominent, you have to write, and what you write has to obtain recognition. But not all things are equal, and again, going back to the fact that we are an elite, prestige-oriented industry. Professors at elite schools have a much easier time placing their articles in elite journals. This has been known for some time, including several studies that I believe one in particular sent the same article on 2 different letterheads and using an elite letterhead obtained all kinds of acceptances and a non-elite letterhead and didn't get any. So this is well known, but even having said that, there are elite professors, there are professors at top law schools that aren't well known and don't do very much. So the quality of the work has to be there, the quantity of the work has to be there, and you get recognition in that way. I think the bottom line is that we see ourselves as academics. We like emphasizing the academic side because it's that gets us lower teaching loads, it's that gets us tenure. Lawyers don't have tenure. And it's in our interest to do that. Now, I don't want to just make this a matter of cynicism. I mean, there are many law professors that genuinely are academics, that have an intellectual turn of mind. I'll give myself as an example. I've now written 7 books on matters of legal theory, by the way. I don't write on the economics of the legal profession. I do this job because I love it. However, the problem is we've become so academic that it's become to the exclusion of recognizing our role as training lawyers. And an example of that can be seen in our hiring patterns. In recent years, the law schools have begun hiring people with PhDs in other fields. Now, it's fine to have advanced education in another field. The problem is that this comes at the expense of them having any experience in the legal profession itself, developing some knowledge about what it means to be a lawyer, because the vast majority of our students are actually trying to get jobs as lawyers. So we're becoming even more academic, again, not because my problem is not because it's not good to learn more, but because it comes at the expense of knowledge about what it means to be a lawyer. In previous generations, a generation ago, I should say, it was also the case that professors at elite law schools had relatively little practice. But at law schools nationwide, generally, professors had some practice experience. I worked as a public defender, for example, before becoming a professor, as well as a lawyer in a developing country. And I thought that was necessary for my own sake, to actually know somewhat about what it meant to be a lawyer. And I think that was a more prevalent attitude. Now it's coming to the point where people feel that if you practice too long, you become tainted in some way that makes you not well suited to be an academic. And this is when I think our priorities have really gotten out of whack, that we've become so academic that we're almost anti-lawyer. And it's a bizarre place for law professors to occupy because, in fact, our students pay a good sum, a huge sum, to learn how to become lawyers. And the idea that somehow this is not a priority of ours, I think, is just really where we've gone wrong.
Quick little story in support of your view. There was a wonderful guy named Howard Glickstein who was the dean for many years at the Toro Law School. And he came to the academic world in perhaps his early 40s or so, after a reasonably prominent career in practice. And he found, when he was seeking a job in the academic world, that the fact that he had been a very successful, that he had been a practitioner and a very successful one, particularly in the area of civil rights where he specialized, that was regarded as a mark against him, as a disqualifying factor. And what can one say? Because Howard was a wonderful person, a fine dean, and I must say it's almost as if in medical school the professors never were anything but research-oriented biologists and endocrinologists and so forth, and instead of, as in the last 2 years, when medical students, having gone through 2 years of mainly or exclusively academic work, now start to be taught by people who keep a hand in the practice of medicine, and they go around with doctors and et cetera, et cetera. We have the legal academy has been run quite a bit differently from the medical academy. You've explained the salary, the methods by which salaries were ratcheted up. Maybe we could discuss just a few other of these rules that have, like ever higher salaries, contributed to higher costs and therefore to higher tuitions. You mentioned extensively in the book the hours of teaching per semester. Maybe you could elaborate on that.
I don't believe the rules had that much of an impact. There was a provision that suggested an 8-hour maximum, 10 hours if you're duplicating courses, but most schools weren't exceeding that and don't today. I think the real problem is, or the cause has simply been action on the part of law professors and the ALS in particular, I don't mean the ABA, to pay attention to how much law professors teach. And as I say in the book, historically, for much of the 20th century, a standard teaching load would be about 14 or 15 credits, 16 at some, and even higher at a few law schools. Whereas today, the standard teaching load is now about 12 credits, and actually it's a bit under that.
That's per year,
so
by
at
the
12,
way, not per semester.
That's per year,
Yeah.
right. So now it's basically 6 hours per semester. Previously it was 7 or 8 per semester. Now this makes a difference because essentially we teach one course less than most law professors taught most of the century. Now this matters because if law professors teach less courses, you need more law professors overall to have the same course coverage. Now I'm just giving you the average load. Now at elite law schools, they now teach between 8 and 10 credits a year, so it's even less than that. And this has contributed to the increase in the cost of law schools because law faculties have expanded. We now, and one sign of this, and we've expanded not just because of more research, we also have more clinical professors, we have more legal writing professors. So the number of students per lawyer has gone down, per professor has gone down from about 25 to 1 to about 15 to 1, the ratio of professors to students.
One of the reasons we have more, and I would say many more, clinical and writing professors is that, at least as to the clinical part of it, probably not the writing part of it, but as to the clinical part of it, the traditional law professoriate is, as I think you've mentioned before here, not equipped to teach it because they have no experience with it.
Yes, many professors. They're still professors with practice experience, but indeed professors who have gone from law school to a clerkship in 1 year in a firm and then obtain a position as a professor are not equipped, don't have the...
And they have no interest in teaching writing. They could, but they have no interest in it.
And nor do they have an interest in teaching clinics. So law schools were lacking in skills training, and we solved the problem essentially by hiring other people to do it, to take care of it.
Yeah.
Helps explain the expansion of clinics and legal writing positions.
Which creates, as you said, a need for many more professors, which jacks up the costs, which jacks up the tuitions.
Yes.
Maybe you would explain the student-faculty ratio and its effect, including, I might say, that this always boggles me, the student-faculty ratio has, I think, nothing to do with the number of students who sit in a classroom, because there are schools with low student faculty, in other words 10 to 1, which is a lot of professors for each student, and they have classrooms filled with 120 and 150 people. But maybe you could explain the ratio, how it was used, and what it meant.
Well, initially it was used through the accreditation process to suggest that if the ratio was too high, if there were too many students per faculty, that the law school wasn't being staffed sufficiently. But in recent years, that's not really been the main driver of it. One is that U.S. News measures student-faculty ratio. It's one of the factors they look at. But really I think the main driver of it has been this really just institutional expansion that law schools, about 15 years ago, what I call it was the Harvard effect. Harvard decided to expand. And when Harvard does something, many law schools follow. And it's remarkable to see. I found a host of law faculties announcing a major expansion of the faculty, even after the contraction of the legal market. Notre Dame announced that it would increase the size of the faculty by 25%. This is really about institution building, about the idea that we get bigger. If we have more professors, we're better. And as I say, institutions began stockpiling legal talent. Now, this is one piece of it. The other piece of the expansion is that we were woefully doing a poor job of training students, and we expanded the clinical offerings as well. But really it's about not having any kind of attention to the economics of it and exercising no restraint, because more professors cost more. If they cost more, you need more students and you need higher tuition to pay for it. And there was a kind of loop in which we haven't mentioned, but the number of graduates have gone up essentially every year, and it's being driven, the number of graduates as well as the tuition, by now what is a voracious need to cover our expenses. As faculties expanded, you need to increase your revenue. Faculties are the major budget item on law school budgets.
I was really surprised when your book points out that Harvard, from I think you said 2000 until today, increased the size of its full-time law faculty from 80 to 120.
Yes.
And all I can say is it worked for Elena Kagan because she's on the Supreme Court now. But I don't think that should be the criterion. How about rules regarding libraries and the size of libraries and the contents of libraries?
I mean, the ABA specifies, and again, this goes way back to the beginning, in which they were writing standards that focused on us being academic institutions. And one of the requirements was that we have significant library collections. Now, what first brought my attention to it is that when I was interim dean at St. John's, we happened to be going through an re-accreditation visit. And the school was operating fine, and yet there were objections about not the size of the collection so much, but the staffing and so forth. And it was at that point that I began to look more carefully at how this accreditation process works. I think the right word to say is that although people were well-meaning on these accreditation committees, they lost sight of the objective of the rules, that is to ensure that you have an operation that's training sound lawyers, and instead looked at what deans have called output measures. How many volumes do you have? How many employees do you have? What are their salaries? And this occurred in connection with libraries. This occurred in connection with facilities, with buildings. How nice is the building? Is it suitable to the size of the student body?
This is more and more problematical because starting about perhaps 8 or 10 years ago, one would have to begin to question whether hard copy libraries almost are even necessary. Now, I love books. I read books all the time. I write reviews. I conduct television shows on them. I'm probably a throwback to the 19th century. But today, virtually everything that most lawyers and most professors need are on the internet. That's just the way it is. And a library could essentially be, for all but the research schools where people do arcane research, could essentially be a small room with a bunch of computers. That covers in a sense, the formally stated rules. And my question is, to what extent, if any, were the problems created not by the rules as written, which sometimes on their face seem reasonably innocuous? You shall have a competent building. Yeah, well, who could argue with that? but by the way the rules have been enforced in a process which is kept, to put it nicely, is kept confidential. Is kept secret would be a less nice way to put it.
Yeah, I think actually the process was more important than the rules. If you look at the rules themselves, they don't explicitly require some of the things I'm objecting to. I mean, there's language there that provides a basis for arguing from it. But what the accreditation process involved was essentially legal educators, groups of legal educators going to law schools, faculty members at those schools putting together essentially plans for the school in which they were able to work things that they desire into the plans when communicating with the site inspection teams. And the site inspection teams would then write these up in the reports. And by that I mean the inspection teams would ask about how much research have you been doing? How much support are you getting for the research? The provisions, the ABA provisions didn't say you have to pay for research. They suggest that law schools should engage in research and support faculty research, but they're not explicitly requiring you must provide sabbaticals, paid sabbaticals. It doesn't say that in particular, but it was interpreted that way. And the reports would then raise objections if faculty research wasn't being supported. So in my view, the culture that revolved around the accreditation process was much more important than the actual rules themselves in bringing about conditions that law professors wanted for ourselves. And again, I don't mean this to be entirely cynical. I think people genuinely believe that these are all good things for law schools. Law schools should have ample research time. We shouldn't teach too much. It's not good. So they genuinely believe these, that these were good things, and that through these beliefs, reports were written in a way that required law schools to do these things. So it's not just about the rules. I think you used the right word. If you just read the rules, they seem quite reasonable. It's about how the rules were interpreted and applied, utilized in the reports that were written to impose things that the rules themselves did not necessarily require.
I have always been of the opinion that there was one person assisted by a coterie of others who fundamentally ran this show and was heavily responsible for what happened. Now, without mentioning names, would you agree or disagree with that?
I'm not a law school insider, and much of my research just comes out of publicly available documents. My experience with the accreditation process was on the receiving end as the interim dean, as I suggested.
Yeah.
I know many
Okay.
people who've engaged in site inspections, and I've heard many rumors about what you're referring to, but I don't know. I don't know about it from my own personal.
I'll tell you one thing that's a fact, and it's something attributable to a person whom I regard as a member of this coterie, who was a very famous person in New York City. And if I go beyond that, he will become very easily identifiable. And he said, and he was also a very famous person in ABA accreditation. He said, "There's not going to be a Honda Law School." And we thought that said it all. There is not going to be a Honda Law School. You can't have a low-price competent school. I mean, the competitive pressures were against that. In 1995 or 1996. The American Bar Association, on behalf of its accrediting arm, entered into a consent decree with the Department of Justice, which brought an antitrust case. I guess I have to concede at our instigation, because we went to the Department of Justice. And then you point out that the ABA, to my amazement, surprise, shock, use whatever word one wishes, proceeded to violate that consent decree.
The main violation was that the committees were supposed to be staffed with people out, not just legal educators. That was a part of the problem. The charge was that that legal educators captured the accreditation process, and mainly because we were the ones going out and doing these things and sitting on committees that would make these decisions. And so they were supposed to bring in university administrators, lawyers to participate, and the ABA was not following the terms of the consent decree. Why the ABA did that, I have no idea. I think it was it's inexplicable to me that they wouldn't make an effort to comply with the letter of this decree. We actually agreed.
Well, you know, I don't think you've investigated this because it just wasn't your interest. But I can tell you that the person who was put in charge was the ABA General Counsel, who had overseen the section when it was doing all the bad things that it was supposed to stop. And then one thing the ABA did, which we explained it to the Department of Justice, but frankly speaking, it didn't care, is that when the ABA put non-professors, non-academics on these committees, they quite often were judges or lawyers who had been academics, had sometimes even been ABA accreditors, and who obviously agreed with what the section had been doing. So nobody ever said the section wasn't shrewd.
Well, that wouldn't have violated the consent decree in and of itself. So they actually went beyond that and didn't staff the committees with non-academics, or at least sufficient numbers of them.
Right. Yes, I understand, and you said that very clearly in the book. And I was just pointing out a little fillip to all
Additional,
this.
right?
Yeah, of a point you make in the book, the extent of the increase in tuitions between 1985 and, let's say, 2010.
I think the best way to do it is compare it to the rate of inflation. So the average tuition at private law schools in 2011 was just a shade under $40,000. And had it gone up just at the rate of inflation, it would be somewhere around $16,000. And public school, I believe, is now up to about $18,000 or $19,000. And had it gone up with the rate of inflation, it would have been around $4,000 or $5,000. So you can see just from those comparisons that that we've gone up far in excess of the rate of inflation. And again, I need to repeat that I'm just giving average numbers. Their private law school, the Yale's tuition is over $50,000. Columbia's tuition is over $50,000. And they're public law schools that have out-of-state tuition that it's over $50,000, and that's Michigan, Virginia, California, Berkeley, UCLA.
When we started the school and we're charging 8, schools around here like Harvard and BU and BC and so forth, charging roughly around 12, 13, 14. So now we're charging 17 and they're charging 40 and 50.
Yep.
Wow. I mean, that's all you can say is wow. And you say in the book, and have said here, if I remember correctly, is very important, and that is the impact and the ways in which there is an impact of the law school rankings put out by U.S. News and World Report.
The ranking really has a really controlling influence on legal academia. We have two controlling influences. One is the accreditation template as applied by academics, and the other is the U.S. News formula. And what law schools have done essentially is tailor their policies in relation, their admissions policies, their scholarship policies, in relation to the metrics measured in U.S. News. I detail several of the quite negative consequences in the book. Of what we've done, but I want to specify one in particular, and that is the allocation of scholarships. Up through the mid-90s, the majority of scholarship money was distributed on a need basis. In other words, it went to students who came from lower economic circumstances. By the mid-2000s, this had flipped in proportion, and the majority of scholarship money is now allocated based on merit. And what I mean by merit essentially is that the bottom half, the students coming into the class with the bottom half LSAT scores and GPAs would pay full price, and the students coming in on the top half with the better GPA scores and better LSAT, and it was primarily LSAT, would get discounts. Some would pay half tuition and some would pay no tuition. Now, there's a perverse consequence that applies to this, that follows from this, and that is that students in the bottom half, although this doesn't hold entirely, often do more poorly. And if they do poorly in law school, they don't get good jobs coming out of law school. So the effect I call a reverse Robin Hood effect. We essentially have a redistribution scheme between the students in which the students likely to be poorer coming out are actually subsidizing the education of the students who are likely to earn more money coming out. It's just one of many strange things we've done. And this relates directly to U.S. News.
I'm sorry, this relates to what?
Our shift in scholarship policies is directly related to U.S. News. Legal educators often complain about U.S. News and blame U.S. News for all the things we've been doing that are highly questionable, including putting up employment numbers that are misleading, including 2 schools that submitted false LSAT GPA medians to the ABA. So we often say it's U.S. News that made us do it. And I think while there's truth to that, we also need to keep in mind that law schools are making choices. And we've kind of lost our way. In this competition for ranking and prestige, we've sort of lost our way about what our own priorities are.
The things that you have mentioned extensively in the book and more briefly here, and they include, it would be nice to call them untruths that have been put forward by law schools and their representatives. Yeah, they strike me as a moral disaster. And I think that you used the word moral somewhere in the book, but maybe I don't remember it correctly. Would it be correct to interpret the comments you just made as de facto saying we have lost our way and a moral disaster has been created? Once all this became revealed, deans have lost their jobs, admissions people have lost their jobs. And of course, one of the reasons they did it, as you again point out, is God forbid that a school should fall 1 or 2 or 3 places in the U.S. News rankings from, say, 21st to 24th. I mean, it just hits the fan. The alumni go nuts, the students go crazy, and deans, I won't say understandably, because I don't think there's any understanding it in the sense of the word understandably. And deans and admissions people do these things because they literally fear for their jobs. The ABA has lobbied and by the 70s had succeeded in having most state Supreme Courts, not all, but most, maybe 45 out of 50, require graduation from an ABA school in order for a student to take the bar in the state. The schools which could have thumbed their nose at the ABA, Chicago, Harvard, Yale, Stanford, Michigan, etc., they didn't care enough to do anything about it. The state courts saying that you had to be a graduate of an ABA school is what permitted the imposition of these various rules. Now, you say, well, obviously then, the way to correct this is for the state Supreme Courts to permit there to be other ways by which a school's graduates could become eligible to take the bar. Perhaps approval or accreditation by some organization other than the ABA. I mean, our school's accredited by the New England Association of Schools and Colleges for these very reasons. And my question to you is this realistic? Is this at all likely to happen?
Well, I hope the state Supreme Court justices read my book. If they do, I think the chance of it happening might be stronger. Frankly, I don't think any of the proposals I suggest in the end are likely to happen. I believe law schools like the status quo and will fight to retain it. I quoted a Montana court opinion in which the dissenting judges made some of the same objections I make in the book, but maybe it's different to hear it from an academic, from someone on the inside saying, look, there's something to this, and we've lost our way. To answer your question directly, I do not believe it's likely to happen.
And I think it is sad, Brian, that the Montana opinion which you quoted, which we here in Andover greeted with great enthusiasm when it came out, is what, 10 or 15 years old now?
Yes.
And it has not caused much to happen?
No.
Sad, sad. Well, let me ask you if there's anything else that you would like to say.
It's not just about accreditation bodies that's driving this. I think a very big driver, unfortunately, is the federal loan system. And the reform, I think, ultimately most important in all of this is to impose restrictions on federal loans. Let me just explain. Up until recently, the federal government guaranteed student loans with no limit, and then a few years ago they began providing student loans directly through the Graduate Plus program. As long as these loans are provided without any evaluation of the likelihood of repayment, any evaluation of the economic return, without any limits on the size of the loan that students can take out, law schools will continue to raise tuition as long as they have students who are willing to come. The federal loan program provides them with the ability to come. So in the book I propose different sorts of caps and outcome tests for loans. Now the main opposition to these proposals will come from legal academics who say that's outrageous, the loans are important to provide access to the legal profession. And my response to that objection is that what limits access today isn't the unavailability of federal loans. What limits access today is the extraordinarily high tuition that we charge. And if law schools are really committed about access, we can provide need-based financial aid. So what's inhibiting access is us, the fact that our tuition is now up to $50,000 a year. So I hope the senators, I hope someone reads this part of it. The op-ed in the New York Times that I published 2 weeks ago focused on the federal loan program for that reason. I wanted to communicate to senators that you need to take a look at the impact of providing unlimited funds, no questions asked. As long as that's the case, tuition will continue to go up.
The problem seems to me to be that not all law schools can afford the high aid that would solve the problem under your suggestion, that the law schools which can afford it are quite often, perhaps not always, but quite often, those schools whose student bodies are comprised of the already affluent, and that schools which make an effort to educate people who have been shut out of education generally and legal education in particular, and who accordingly charge very low tuitions, probably cannot afford to stay in business without federal loans. And if they can't stay, or guarantees, and if they can't stay in business, then the very schools that are making an effort to provide social and economic mobility will be the ones harmed by curtailment of federal loans. Well, that's the objection, and what do you think about that?
You're right, except insofar as that should be an important consideration when the cap is set. So for example, I propose two different kinds of caps. One is to cap how much money an individual student can borrow from the federal government. The other is to cap how much money any particular law school can get from the federal government in a given year. So the cap can be set at a level that takes into consideration precisely your concern. The figure I came up with, and it could be any, I was just using it as an example, is to say that, that law students should not be allowed to borrow more than $120,000.
Which is a lot, by the way.
Now, that's what I was going to say. So really all that's saying to law schools is set your tuition at $20,000, you'll be okay. In fact, you can set it at $25,000, you'll still be okay. So I wasn't saying cut it off. Of course we need access and students need to borrow. I borrowed money to go to law school. My parents are school teachers. The problem is that because there's no cap, there are law schools with average indebtedness of $150,000. And these students are not going to pay, they will not pay this money back. Especially if you look at the schools and the placement rate upon graduation, which I have. So I'm really setting a cap as a way of protecting the students ultimately from taking on debt that will be unaffordable to them and imposing restrictions on the law schools in terms of how high they set their tuition. But I absolutely agree with you that we need to, whatever caps are put into place, need to be done with attention to maintaining access.
To the audience, thank you for being with us. and we hope that you will be with us again next time.